Civil litigation. Now we can sue the federal government and try to get them to listen to what we have a problem. Okay, and there's two reasons why that's not working. It basically has to do with government has passed laws that give them government immunity. You cannot sue a public official for doing his public job. It will be dismissed. You will never get a hearing. And then the second is what's called lack of standing. And what that basically means is this. It means that if you are suing in behalf of people besides yourself, in other words, if you don't have a unique personal damage to your right, life, liberty, or property, then you do not have standing and they will dismiss that. Now, Tana and I have talked quite a bit about this. I'm going to surprise Tana and probably some of you. I sort of think that that may be some truth to that. What would happen if let's say every time people in our country did not like the outcome of the elections, that they could tie everything up in the courts, we could spend millions and billions of taxpayer dollars fighting and arguing over every issue that people didn't like when things were voted on by the majority of the people. What would happen to our whole political process system? You could tie it up in the courts for decades and spend lots of taxpayer money. I do think there is a legitimate reason that we don't let the courts do that. Let me give you another example. When there was the Gore versus Bush or Gore versus USA or whatever, and Vice President Al Gore and the Democrats tried to reverse that, the courts basically said that we're not going to do that. I think it's a very bad precedent when you have an appellate judge or 5 out of 4 Supreme Court judges reversing the elections for technical reasons or whatever. One time it may work for you, and 10 times it may work against you. You see what I'm saying? So even though we may be upset and we feel that we need to know whether our sitting president is a legitimate, constitutionally eligible president or not, I believe that there is a legitimate reason, maybe reason why it is a good thing. And I can't let you talk. Okay. And let me give you another example. In the Judge Carter ruling, when Judge Carter ruled that he said the plaintiffs are asking the courts to put a temporary restraining order prohibiting the sitting president from being the commander-in-chief and doing, he says, you're asking me as a judge to prohibit the president that the people elected from doing his job. And he said, I can't do that. Now, a lot of people attack Judge Carter, but I think if you had an open mind, you could possibly see that he may have a point. So I'm not even sure but I'm just sharing with you devil's advocate here. So the question is civil litigation as a means. The courts are telling us that this is more of a political problem than a legal problem, and to a large extent they are right. So civil litigation, criminal litigation through impeachment or citizens' grand jury criminal indictments, we could try to criminally prosecute our elected representatives. How's that working for you?
Because judges won't hear them.
Judges won't hear them. Attorney generals won't prosecute them. They're going nowhere. They are going nowhere. And the reason is government almost always will protect their own. Almost always. Okay? So we've got 1, 2, 3, 4, 5. Let's get to the next one. Continental Congress. We had a Continental Congress in Illinois. Tana was at that Congress. But here's the problem. Unless unless it's sanctioned by our state elected representatives, it probably doesn't have any chance of success. Even though it was the right thing to do, even though we were trying like the Dickens, unless we have some legitimacy from our elected representatives at the state level, probably not going to go anywhere. All right, we have state or county nullification of laws through asserting our sovereignty outside the enumerated powers. How's that working for us? Oh, okay, all right, so it works occasionally.
It would work more if they had the guts to stick with it.
Okay.
This stuff can work.
Oh, yeah, it can work. No, there's no question it can work.
It can work.
All right, so, but we don't use it, right? Most of the time, we're not using it. We can secede, right? If we don't like what's going on, we can secede.
Lincoln settled that.
I'm just talking, those are
First of all, well, let's get this right. There's two different things from seceding from the Union and seceding from Washington, D.C. I want to secede from Washington, D.C., not the United States of America, because they are two different things. Washington hasn't been about America for years.
Well, okay, I've really got to wrap this up. So here's my point. Here are 9 constitutional check and balance remedies that we have available to us. Oh, no, there's one more. Forgot this last one. How could I have forgotten it? The last and final one, our Second Amendment rights. Right? Okay, that's our last one. So I have come up with 6 conclusions. I want to see how many of you can come up that match mine. You might come up with some I haven't come up with. But what are some conclusions that you can make by looking at these 9? Let me, for the sake of time, share with you my 6 observations so we can get through on time. The first is petition our Congress is the most ineffective. Oh, I'm going to go back. Petition our government has not been effective. Would you agree with that?
Yes.
We're basically fighting our own government on every step of the way. Second observation is petitioning our courts is also ineffective. Would you agree with that?
Yes.
Third, all legislation not found in Article 1, Section 8 of the Constitution is null and void and only applies to the may only apply to the geographic territory of Washington, D.C. and other federal lands unless we give consent by our silence.
Correct. That's not technically true.
No, I know, but if we're not objecting, it kind of
There's
just...
powers given in constitutional amendments, so there's more than 18 powers.
Well,
But
okay.
not to be a stigma.
You're such a troublemaker, Tom. I'm trying to keep this simple. All right, so would we agree that petitioning Congress isn't working, petitioning the courts is not working, and that any law that is outside of their constitutional authority is null and void? We're so far in agreement with those 3 observations, correct? Then the next one is, we have not used or exhausted all of our constitutional remedies. Now here's another one. Each following remedy increases the likelihood of violence. Every time we go to the next protection, we're going to have a greater chance of violence. And here's the last observation. For those patriots in the group, and I don't think we have any in this group, but I know that there's a few, who think that they want to jump to the last one and defend themselves against every level of government, in my opinion, that is a losing strategy. That is a loser. And there's no reason to jump to the 9th when we haven't been using the other 8. So that's my observations. Okay.